Good morning. I'm Adam Eben, the chair of this Cannabis Oversight Commission, and this is our final meeting prior to the legislative session, so we have a few things to go through this morning. Why don't we briefly have the members who are seated on the dais introduce themselves, starting with Delegate Scott.
Delegate Don Scott, good morning. Representing House District 80, soon to be House District 88, I think. Welcome.
Oh, I apologize. Will Moorfield, I represent the 3rd House District in Southwest Virginia, soon to be the 43rd House District.
Good morning. My name is Dawn Adams, and I represent House District 68 in Richmond, Chesterfield, and Henrico.
Good morning, Delegate Charnel Herring. I represent the west end of Alexandria City.
As I said, I'm Adam Eben. I represent the 30th Senate District, parts of Alexandria, Arlington, and Fairfax.
Hello, I'm Paul Krizak. I represent southeastern Fairfax County, which is the Mount Vernon and Lee portion of Fairfax County, 44th District.
Senator Jennifer McClellan, representing the 9th Senate District, which you are in, welcome, which is parts of the city of Richmond, Henrico, all of Charles City County, and part of Hanover.
We're going to have discussion on a number of legislative proposals today, but we have a presentation from the Department of Corrections. I understand that Dr. Thomas Selly, Director of Research for Department of Corrections, is with us virtually and has a PowerPoint about people who are incarcerated with a marijuana-related charge or an affiliated marijuana-related charge. Dr. Selly, can you hear us?
Hello.
Great. If you want to share your PowerPoint, we're all ears, and we'll listen for your presentation. Dr. Selly, I don't know if you're muted now, but we can't hear you right now.
Hello?
We can hear you. Can you hear us? Lily, we're not muted, are we? No. Okay. Are we having a technical difficulty or?
Something's technical.
We could proceed with our other business, but let's see, we're getting an IT phone a friend.
If you would like to share your screen, and then we can see it in the room. So in the lower center of your Zoom, there should be a share screen option. If you'll click that and then open your presentation. Otherwise, if you would like to just speak to the room, we can hear you. And if you want to turn on your video, then we would be able to see you.
I'll tell you what, if Dr. Selly, we can't hear you right now, so if you want to speak up, but otherwise we're going to proceed with other parts of the meeting and come back to you if need be. I guess this will be our last call before we move on and come back to you. Dr. Selly, can you hear us? Okay. I don't know if you want to disconnect and phone in again if there's a problem, but okay. Well, for members of the commission, we'll come back to this. We're expecting a presentation on sentencing, and but we have a number of policy proposals to go over today. We've discussed a number before that we can affirm with a formal vote at the end of the meeting, but let's start on the chart that was distributed to you that says actions to be considered. I believe it's on page 2, where it says cultivation categories. And it talks about the law creating two classes of cultivation licenses, Class A for marijuana and B for hemp low THC, with both classes counting towards the 450 cultivation license cap. One of the items that we discussed at our last meeting was establishing allowing the Cannabis Control Authority to issue all licenses except to adjust license caps except for retail licenses. But I'm going to ask Delegate Adams if she'd like to discuss this further. We had talked prior to the meeting, and Delegate Adams thought it made sense to establish a single cultivation license class for all consumable cannabis products and allow the CCA to set the cap for that. Do you want to explain anything beyond that, or? About having the license, a single cultivation license class. Is there any?
Right. I'm having trouble getting my internet with my notes, so I mean, I could talk off the top of my head, but it makes me uncomfortable to do that.
Okay.
So if you can, let me just keep trying to get internet.
Okay, we can come back to that.
Thank you.
Next, a major topic that I know Delegate Moorfield is particularly interested in was the inclusion of hemp growers. To meet early sales benchmarks, Virginia's going to need a diverse, proven partners to supply cannabis. We had discussed at the last meeting allowing the pharmaceutical purveyors to get into the retail market, and we've heard from some hemp folks, Ms. Gaston and others, about allowing the people who had been involved in industrial hemp before to participate. The proposal that has come to me was to limit license transfer to eligible industrial hemp processor licensees who are registered prior to March 31st, 2021, and limiting license transfer to eligible industrial hemp processor licensees who process more than 40,000 pounds of hemp under their permit. And I don't know if Ms. Gaston or Jack would like to come forward just to answer any questions on that or underscore anything that was mentioned, if you want to step forward. This would be in addition to the pharmaceutical folks, and what we're talking about, I believe, was up to one per health district, with the same, that they would have to not only have been in that business prior to March 31st, 2021, but they would also have to meet the same standards as the pharmaceutical purveyors, and that they would be basically applying for a license and then would pay, if they were vertically integrated, the same $1 million fee that the pharmaceutical folks would. Did you want to talk about, you had sent me some information about geographically that they're not all just in one health district. Is there anything else you'd like to add or confirm?
Sure. Good morning, Mr. Chairman, members of the Commission. Susan Gaston on behalf of Purely Appalachia. It's a pleasure to be with you all today. Happy New Year. I have with me my client, Tom Griffin, and I think Tom actually compiled that list, Mr. Chairman, of the various hemp processors throughout the Commonwealth. So if it's acceptable to you, sir, and to the Commission, I will resume, or I will step away and let Tom resume the podium.
Great, thank you, welcome.
Great. Thank you, Mr. Chairman, and thank you to the board for giving me the opportunity to speak with you today. My name is Tom Griffin with Purely Appalachia. Loosely speaking, Senator, what we were tasked with was determining a framework that would allow for some sort of agreed upon framework for a limited class of commercial industrial processors, hemp processors, to enter the platform as vertical licenses along with pharmaceutical processors. At the previous commission meeting, it was requested that the industry get together with some of the pharmaceutical processors, which we did right before Christmas here in Richmond. We were able to meet with representatives, a couple of the providers, myself and another provider with the, on behalf of the industrial hemp processor community, as well as the pharmaceutical processors. Loosely, what was agreed to was a framework that would allow for up to 10 vertically integrated recreational licenses to convert at a date determined by the board. What was proposed and the legislature, what was proposed at the meeting was July 1, 2022. That date would trigger the opportunity for the 5 pharmaceutical processors to begin the process to convert to recreational cannabis licenses, vertical licenses, as well as on the same date begin the process for what we've called an RFP or application process, similar to that which the pharmaceutical medical licenses were requested to go through upon becoming medical licenses, that up to 5 industrial licenses would be subject to going through. The group met and discussed that concept, among other things. But with regard to what's before you currently, Chairman, that was sort of what was loosely agreed to.
And that was five hemp licensees in addition to the pharmaceutical?
Yes,
okay.
sir.
Okay. Are there questions? Yes, Delegate Herring.
Thank you. Who's in this group? You said the group, so who's in the group?
So of the group, you're talking about the group that met right before Christmas. We had representatives and principals from Jushi, GTI, Columbia Care, and there was one other provider that I don't recall. Oh, and excuse me, yes, and of the industrial hemp processors, our group and a group from South Boston called Golden Piedmont, who's represented here today. And several of those groups are represented here today as well.
Thank you.
Are there other members with questions? I'll ask one. Ms. Gaston had sent me a list of different hemp providers that would presumably be able to qualify, and they were located in Lebanon, Stanton, Christiansburg, Winchester, Boykins, Haymarket, South Boston, Danville, and Portsmouth. And do you know of the different health districts, how many are represented amongst that?
We've had I would say this, Chairman, that we can give you a comprehensive list of all industrial hemp processor registrants. I would argue that is a broad term of art, and there are probably some entities that would choose not to participate in this program or would be incapable of participating in this program at a commercial level. I think that there's probably a variety that would as well. We have worked collectively to try to determine who those providers are. The list before you is sort of at least a minimum 9 that we know with certainty that would have the interest in participating and would have the commercial capability to participate. But that's an item that we've been trying to work on. Unfortunately, the data with VDAX doesn't give us a broad understanding of the footprint.
I guess what I'm asking is it seems to me that they seem somewhat spread out. I didn't know if the one in Winchester, I didn't know if that's considered part of the Northern Virginia Health District or if that's a different health district. That's probably
know. Yeah.
Okay. But it seems to me that you've got at least 3 health districts represented, maybe more, without having a map to double check, which I think is important that we're not talking about them all in the same part. But I think Delegate Herring may have a question.
Yes. I was just curious, and I apologize if I overlooked it. Was a list sent to everybody?
No.
Okay.
I just got it last night.
Okay. Well, I can't make a decision on something without information, so.
Well, this is not a formal proposal. It's just a list of some of the locations of hemp purveyors. I just was reading the geography, and I can do that again. It's not a proposal. It's just that they happen to be located in Lebanon, Stanton, Christiansburg, Winchester, Boykins, Haymarket, South Boston, Danville, Portsmouth, among the ones that they're citing as examples.
Mr. Chairman, I have a question.
Yes, Delegate Krizak.
So you say there's 9 that would probably qualify and that could do it, and I assume that means they could also do it soon. How would that be, and I apologize if I didn't catch this earlier, but how would you winnow them down to the 5?
Sure, Mr. Chairman. Delegate, that's a great question. And to clarify on, I think for both delegates, the question as to the 9 providers that was in the list that was provided. We had met with staff, and they had asked us 2 questions. One, can you help us understand what type of regional coverage across the state exists for these providers? Because if they're all concentrated in one area, that would obviously potentially provide a challenge with coverage into some of the other health districts or regions or however you want to space out these processors. So to the best of our ability, we tried to determine some providers that we knew had some commercial capability that were spread out throughout the state. I do not believe that's an exhaustive list, and I am certain that there are other providers out there that, but what we wanted to convey was, because there was a question as to, are there even 5 providers available that would be able to do this? And so we wanted to at least convey that, yeah, with certainty we can certainly point to, close to double that amount and potentially more that are out there that might be interested and could provide coverage. Then the second question regarding how you would whittle those down, we have proposed, and this is something that I think is very important to the pharmaceutical processors, they have understandably had to go through a very rigorous process to onboard to become medical licenses. We think that is appropriate in most state markets that we've observed with either medical or recreational vertical licenses. The state rightly puts the provider through a very rigorous onboarding application or RFP process. And so our suggestion would be, and I know that there's some question as to whether or not we would move this from one entity to the other, from the Board of Pharmacy to the CCA, but wherever that lands, our answer to that question would be that we be onboarded through a similar process equal to the standards that the pharmaceutical processors are being held to.
Okay. Well, then, I think we're open to discussion now. So the question, well, I do have one question for you before you leave the microphone, which is, you suggested limiting license transfer to eligible industrial hemp process licensees who process more than 40,000 pounds of hemp under their permit. That's a category that's a black and white category that you can, 40,000 that's on record. So,
yes, Chairman. Subject to your registration, you have to submit reporting to VDAX in order to continue to operate. So you could substantiate what your throughput was as an operator. I would offer also, just to add to that particular piece, that was sort of we've gone round and round to try to determine how do we define what a commercial hemp processor is. I think there's a variety of different ways you could categorize that or define that. That's what we came up with. We certainly, however, think that if you make the process for onboarding rigorous through an application process and you assign a significant fee for onboarding, that will probably have a natural filtration for some of the providers that would be financially and operationally qualified to operate versus those that would not or may care not to be vertical licenses. So that's an option that's available to the board for consideration. We think it certainly captures and speaks to a commercial level of operation for a provider that would participate. However, that's one suggestion.
Okay. And is 40,000 pounds is that a category like the highest category, or I don't know much is that how do you derive that number? Is that the highest level?
Candidly, it's not a top or bottom threshold. Just seems like sort of we just to give you some insight into our thought process there. We had walked through a process to say, well, we've done several 100,000 pounds of throughput, so we could set the marker there. Then we kind of decided, well, let's scale that back and start talking to providers to see what a reasonable throughput would be. That seemed to be sort of an average number that met the satisfaction of most of the commercial operators we spoke with. But it is, it is just sort of a number we arrived at. It doesn't necessarily define a specific category of commercial output or throughput.
Okay. But just to underscore, there are at least 9 or 10 that would meet that level.
Correct.
Without having every person who engaged in hemp farming at a smaller level would not necessarily meet it.
Yes, sir.
Okay. Delegate Herring.
Yeah, and also Delegate Scott also has a question, but since I'm next to you. So I just want to make sure I understand, and excuse this question, but 40,000 pounds, how many acres of land? I'm just going, I just want to get an idea about who we're talking about and that we're not honestly leaving people out. So how many acres would allow me to generate 40,000?
Thank you, Delegate. That's a very good question. It really, the answer is that it can vary. Typically, what we've seen with industrial processors is that they don't necessarily grow all of their own product. And so in many cases, they'll contract with farmers in the region that can either be providing outdoor grow in the form of acreage. So that can be, to give you some sense, 40,000 acres, 40,000 pounds would possibly be, 40 acres, something like that, if you were to translate that. It all depends on yield and harvest cycles, et cetera. Also, we're defining that as the aggregate total of throughput, so it doesn't necessarily mean 40,000 pounds per harvest. It could be, 2 years' worth of processing that defines, a total throughput of 40,000 pounds. So I can offer you this example, Delegate, just if this offers some clarity. In the case of the program that we operate in Lebanon, Virginia, we work with, we're located in the Southwest region. As everyone on this committee knows, there has been a lot of focus on hemp farmers from that region who did enter the market in a very major way in the Southwest region. And so our clients have ranged from very small operators with, maybe a half an acre or an acre of grow in their, on their own personal property, just, private residence, all the way up to, larger providers with, 10 acres, 20 acres kind of grows. And so it ranges widely.
Okay, and I think Delegate Scott, did you have a question?
I did. Thank you, Mr. Chair. I'd ask, and I may have missed it in the emails or whatever. They said the medical providers and the hemp met together. Y'all are in agreement on the safety procedures and security that the seed tracking. I just did a visit last week, and so they're very specific in those medical providers, the processing where they track every single seed from creation to sale, and you guys are going to do that same thing?
Sure. Yes, thank you, Delegate. Also a very good question. I can't speak for the entire group, but I can speak for our group, and when I say that we have been advocating for the exact same standards applied to the industrial processors as would be and are currently applied to the pharmaceutical processors. And to expand on that just a little bit, I don't think there's any commercial cannabis program in the country that has been a success without very rigorous uniform standards with regard to safety. That's extremely important to our organization.
And Mr. Chair, follow up. I have recently read a very detailed report from California that showed that they don't have this type of security. They don't have this tracking. They're doing a lot of pop-ups all over the place, all over the countryside in remote areas with these pop-up centers where they can grow, and they have some forced labor and some other issues. I want to make sure that we don't get into that, but I also wanted to ask you, I didn't hear anything. We've had a big push, at least on this side of the aisle, around social equity, and I wanted to make sure that that was I didn't hear anything from the hemp growers. I've heard the medical processors talk about their commitment to doing a program that focused on social equity. I have not heard that from hemp. I know there's a USDA disadvantaged farmers program. I was wondering if y'all were involved in that, or do you have any data right now that you could report on the diversity of these folks who are going to be coming into the industry on hemp?
Sure.
And then I have another couple of questions. Go ahead.
Sure. Chair. Delegate, yes, thank you. Obviously the social equity component is a major topic of discussion and has been for the last several months. When we put our group together, Purely Appalachia, it was specifically represented by individuals from the southwest region of the state, which is the region of the state we seek to serve, and that were specifically held one or more social equity criteria. Understanding that was going to be a major emphasis of Senate Bill 1406, we assembled a team of over 100 people that would represent various positions within the organization, all of whom had one or more markers for social equity. Now, I would offer one follow-up to that, which is, and this is something I feel very seriously about and something we've mentioned to several of the legislators about. Should the debate surrounding social equity change in any way, our commitment to the providers that we've worked with in our region will remain the same. We've vetted them, we've trained them, we've interviewed them. We want to work with them because we want to work with them. I would argue as well, one of the major criteria in the social equity components that exist in 1406 is that an individual be from a economically distressed region. We serve a region that is, the majority of which falls into that category. And so by virtue of their residency, they meet that criteria. Our commitment remains the same. Our commitment extends not only to working with those individuals, but we have set up an organization to try to assist individuals in that region into getting licenses, both for cultivation and retail in the region, so that they can stand up their own small businesses once the horizontal portion of the program goes live. So we are very much committed to that. But I know that this is we're in a strange space with that debate right now, and I think that's something that's evolving. So from my perspective, we would operate, with those providers no matter what.
Last question, I think, Mr. Chair. I'd ask the list of folks that you said in the different regions. I think there's 9 of them.
Yes.
Those 9, how many are already licensed, and what's the average length of those licenses? Are those new players, or those folks that have been in existence for a period of time already? Thanks.
Sure. Thank you, Delegate. They all of those 9 that we selected, we believe have commercial throughput consistent with our proposal. And we were actually tasked by the staff attorney from, I believe, this commission, Senator, to actually see if we could bump that timeline up further than the April 31st, 2021 deadline that we contemplated for licensure. So all of those license holders were licensed on or before January 1, 2021.
Okay.
Thank you, Mr. Chair.
Thank you. Delegate Krizak, you had a final question on this topic?
Yeah, and we mentioned this a little bit last time, but I just want to throw it out there. It's the concern about, and there's something that you just mentioned that also I'm a little bit concerned about, but it's in the same vein. The hybridization of, the cross-pollination between marijuana and hemp that grows out there, and apparently in Colorado it's a big problem. And you mentioned outsourcing to farmers, and it sounds like a great idea on the surface, but I'm a little bit concerned, kind of following up with Delegate Scott's security question. And I think that would require some serious change to the legislation as contemplated or as we passed it last year, about, basically your subcontracting, if you will, to other farmers. So for the outdoor grow, how do you handle that security aspect of it? How do you contemplate handling that, and also the problem of cross-pollination?
Sure. Chairman. Thank you, Delegate. Yes, that is a major concern. And when we were discussing the hemp grows and processing facilities that exist in the Commonwealth today, they are legally allowed to, contract with, farmers. But to your point, even with hemp, we have heard from farmers that have security challenges where, looks and smells similar to something that might have recreational value. We know that it doesn't, but there have been some, examples of, kids getting onto property and, that kind of thing, and that happens. The other concern that you have is very real as well, having to do with cross-pollination, drift. As I'm sure everyone on this commission knows, marijuana flower is grown from female plants only. If you cross-pollinate those with male plants, they render the plants unusual, or that flower unusable. And so, for the purposes of what we're talking about here, and so what I've seen in states, this is just my own personal observation, what I've seen in states where they have allowed outdoor grow is that, yes, there absolutely has to be strengthened security requirements above what's required in the Commonwealth for hemp farmers. That's going to add a cost, it's going to add a degree of regulatory oversight, and it's going to require challenges that I would imagine some farmers will have to adjust to, because the VDAX currently does not extend that same level of security for outdoor grows. So without a doubt, perimeter fencing, security, a variety of factors in this, for security are going to have to go into how you contemplate what all of your cultivation looks like, both with your commercial vertical operators as well as with your horizontal, individual cultivators, be it indoor, be it greenhouse, or be it outdoor, if you see fit to allow for outdoor. When we're talking about outdoor with regard to cross-pollination, what I've seen some states do that seems to reasonably work is just having a distancing requirement. Because typically what we've seen, and there's a lot of debate and data to suggest what the appropriate amount of distance is. Is it 5 miles? Is it 10 miles? And I think you all would have to kind of work through what that looks like. But if you incorporate a bad grow a mile down the road from my grow, and there's some male plants in that grow, and the wind picks up and blows it to my acreage of female plants, that can cause me significant problems. So that's absolutely something that the legislature will need to think about.
And just to follow up on Delegate Krizak's question, do you anticipate, say your firm, if you were granted a license, would you then be engaging just in growing consumer-grade cannabis rather than also the hemp at the same time? In other words, would it likely be an either-or for most of the people who are granted a license?
That's an interesting question. I think that, if the legislature sees fit to say, full conversion means full stop on the hemp, then we would obviously accept that provision because I think that our interest lies more in, operating a cannabis company than a hemp company given the market. However, having said that, if you were to allow both pharmaceutical processors and industrial hemp processors to cultivate hemp in addition to cannabis, I would offer you that there are, blending ingredients, there are hemp-based cannabinoids that any cannabis provider would want to provide in its products. It's not uncommon to see a blend of, a THC cannabis product that has a blend of THC and a cannabinoid, which you could derive from hemp. And so there may be reason why cannabis operators would want to draw from hemp-based grows in order to create some of those ingredients. But again, if that's a hard stop in the eyes of the legislature, I think I don't want to speak for everybody. I can speak for our firm that we would certainly say, well, we would give up hemp in order to do cannabis. But there is probably some value to allowing providers to grow some hemp in addition to the cannabis grows.
Okay, thank you. If there are no other questions, I'm just going to restate the proposal to get the committee to have a discussion on this particular topic. Was there any discussion on this topic before we were get to our
Did you want me to just talk about the licensing?
Oh, we'll come back to that
Or- oh, it's
unless this
different?
is specifically about allowing the industrial hemp people to convert to a cannabis license. If it's on that topic.
Well,
The floor is yours, Delegate Adams.
I'm sorry, Mr. Chairman, and I apologize, my internet connection is not serving me well here. I think Verizon works better. Is that my mic? All right, thank you. So I guess it must just be me. I'm buzzing. Okay, what my thought was, broadly, when we're talking about two types of licenses, is it a necessary thing? Because historically, when we've talked about industrial hemp, I think that is a really very different situation than what we're sort of talking about hemp use for now. And so I just kind of think that if we were going to have two separate licenses, we really should be thinking about it a little differently in terms of consumable hemp and non-consumable hemp. So that, what we're really talking about is if you're going to grow large biomass of hemp for the purposes of essentially extraction and remediation, and the cannabinoids that you're getting from them, one of which is also THC, you result in sort of large volume THC. That's going to be the end of that. So then it becomes, well, then what do you do with that? How do you regulate that? And so I just see that it seems sort of more streamlined and simple to have one license category that we regulate the same. So without my more in-depth notes, that's the overview.
Thank you. Let's go back now to the proposal that we have about hemp. So the question is whether or not we would allow for a rigorous RFP process to provide for up to 5 vertically integrated license meeting the same standards as pharmaceutical processors to the limited class of participants who had an industrial hemp license prior to March 31st, 2021, and had processed more than 40,000 pounds of hemp under their permit. That's the question, you know, and the benefits I see, one of the benefits I see is that if we flip a switch on January 1st, 2023 and allow for consumer adult use cannabis, that we want to make sure there's an adequate supply, and the pharmaceutical firms that are eager to get into this business will be meeting some of that, but I think making sure there's adequate inventory is a wise course. Are there comments before we vote on whether or not to endorse this proposal? Delegate Herring?
You know, it's got something to say. So, and I just am not going to vote on this because I totally support. So, especially with smaller farmers, I really get it, and I really want to support this. But at also risk is also the social equity license when we're talking about other individuals. And until that is resolved and worked out, I just cannot do anything right now. But I totally get it. I'm with you all. But I'm just hoping, and I appreciate your statement about your company's commitment. I appreciate that, and I hope that all companies are committed. I'm not sure that's the case. And until we can get that sorted out, I just can't cast a vote today on this.
Okay. And I'll just remind members of the committee, we're talking about changes to last year's bill that had a reenactment clause. No one has proposed, at least at this committee yet, changing the social equity requirements. Were there any other comments on this? Okay.
Mr. Chair.
Yes, Delegate McClellan, Senator McClellan.
One option is we could hold off a vote on this until we get to that portion of the meeting. We've heard the recommendation. I think
Okay.
we've vetted it, but I think that Delegate Herring raises a valid concern, and perhaps we should take these two together.
Sure. Okay. Then, in terms of social equity, what I had on our discussion list, based on the JLARC suggestion, was rather than extending eligibility to family members of and you can be seated if you'd like now, formerly convicted persons, that greatly increases the number of people eligible, likely more than 3 or more family members qualifying for each person, which could be 300,000 people or more. Increasing the competition for social equity licenses. So what I was going to suggest was that we change it to someone who was significantly impacted by a cannabis arrest of themselves or a family member, and allowing the Cannabis Control Authority to decide what significantly impacted by cannabis arrest means. In other words, if they were a child of a parent who was convicted, or if not necessarily your an adult whose child was convicted, that leave that to the CCA to define and get into the nitty-gritty there. Or if a person was, that they were either significantly impacted by their or a family member's conviction for a marijuana offense, or 2 of the following: resided in an economically distressed area, resided in a high marijuana law enforcement area, or a graduate of a Virginia HBCU. That was the only suggestion that I was going to make in terms of altering the social equity licensing from last year's bill. Are there questions or discussion on that? Any opposition to saying that it would be someone who was significantly impacted by cannabis arrest rather than just saying anyone whose family member had been arrested?
Mr. Chair.
Let's start with Senator McClellan, and then we'll come to Delegate Herring.
I think a person significantly impacted, depending on how defined, could be even broader than family member. I wonder if we might want to consider, I understand the concern around family member could lead to a large number of licenses. Perhaps we focus on those who were dependents, because if you were a dependent and the person you were dependent on was incarcerated, that's very different than if you are not. And I would be, those are the folks that I would be most concerned about having some real mechanism to participate in this market.
Okay, I think that's a good suggestion. I would treat that as friendly to change it to say someone who was either arrested or significantly impacted by cannabis arrest as a dependent of a family member arrested. And Delegate Herring?
So significantly impacted, I'm getting in the nitty-gritty, but that's vague, and it's going to cause problems.
Well, I was going to let the Cannabis Control Authority kind of wordsmith that.
With the with the regulations. All right.
Okay, are there other suggestions on that part of the equity provision of the bill? This would be to change it to say that you would be eligible if you were significantly arrested or significantly impacted by a cannabis arrest as a dependent of a family member of someone arrested, or a person who meets two of the following criteria, and that would be resided in an economically distressed area, resided in a high marijuana law enforcement area, or a graduate of a Virginia HBCU, with the Cannabis Control Authority to work out those details on which applications would qualify. Okay, no other discussion? Okay, I think what we'll do is just take these votes at the end in a group and pull out any that people want to isolate. Lindley, did we get any luck with our guest speaker? Okay, so Dr. Selly, if you're there, speak up and feel free to share your screen with us.
I am here. Thank you very much, and I'm going to go ahead and share my screen now. And I think you should be able to see this. If you can't, please let me know. All right, would you like me just to go ahead?
Yeah, and we're just trying to get your screen on screen again, but I know it's visible to Lindley, so why don't you go ahead and start?
Okay. Okay. Do you want me to go ahead and start?
Yes, please. We can see it now.
All right, so I was asked to talk about the state responsible inmates with marijuana convictions, and for those of you who may not be familiar with the terminology, to be state responsible, that means you would have at least one felony and a sentence of 1 year or more. All right, so just starting with some very basic numbers, and this is as of August 31st, 2021, we had 570 state responsible inmates who were incarcerated with a total of 599 marijuana-related offenses. So that was less than 2% of our total state responsible population. Among those, 229 inmates had a non-drug related most serious offense. So in other words, while they had the marijuana charge, they had another type of offense that was not drug related that would be considered more serious. 331 inmates had a drug sales most serious offense, and 10 inmates had a drug possession most serious offense. And just a reminder, when we're talking about drug possession, that also includes possession with the intent to distribute. So taking and drilling down a little bit, for the 341 inmates with one or more convictions for marijuana-related drug sales or drug possession most serious offense, 331 had a most serious offense that was not marijuana-related, and their most serious offense was drug sales for meth, cocaine, or a Schedule 1 or 2 drug. 10 had a most serious offense that was marijuana-related. All 10 of those were convicted of NAR 3067 F9, which is marijuana transport into a Commonwealth 5 pounds or more. All 10 of those were expected to be released within the next 6 years. And just to note that when we looked at the release information, that was prior to the new good time earnings rate. So they may actually be getting out earlier than what we had on record at that time. Right, so specifically, we were asked to look at the marijuana offenses with mandatory minimum sentences, and we had a few of those. So first, I'll talk about NAR 3063 F9, which is marijuana to sell less than 1 ounce to a minor, and it has a mandatory minimum of 2 years. As of August 31st last year, we had 13 inmates serving time for at least one conviction of that offense. Their expected release dates were 2 would be getting out in fiscal year 2022, 5 in fiscal year 2024, and 6 after fiscal year 2024. The most serious offense for these inmates include 5 had a most serious offense of rape, sexual assault, 2 had a most serious offense of felony assault, and 3 had a most serious offense of other sex offenses, and all of those would be felonies as well. 1 had a burglary offense, and 2 were drug sales. The next offense we looked at was NAR 3067 F9, which is marijuana transport into Commonwealth, 5 pounds or more with a mandatory minimum of 3 years. And as of August 31st, we had 24 inmates serving time for 1 or more of those convictions. Their expected release dates were 2 in fiscal 2022, 7 in 2023, 5 in 2024, and 10 after 2024. The most serious offense for these inmates is 1 had a other sex offense, 2 were larceny fraud, 2 were conspiracy, 9 were drug sales, and 10 were drug possession. And again, just a reminder that for the drug possession, that would include possession with intent to distribute. And then finally, we had NAR 3114 F9, which is marijuana mixture distribution, 100 kilograms or more with a mandatory minimum of 20 years. And we had 1 inmate serving time for at least one of those convictions. The expected release date for that inmate is after fiscal year 2027, and the most serious offense for that inmate was drug sales. And then we also had NAR 3126 F9, which is marijuana sell less than 1 ounce to a minor, where a minor assists in distribution with a mandatory minimum of 2 years. And we had 1 inmate serving time for at least one of those convictions. The expected release date was in fiscal 2026, and the most serious offense for that inmate was rape, sexual assault. And that's what I have to share with you. If you have any questions or need me to go back on anything, I'd be happy to do so.
Yes, I think we probably will have some questions. Are there members of the subcommittee with questions? Can you, Dr. Selly, can you just break down to me what would be the least, in your estimation, the least serious charge that someone is incarcerated for in relation to cannabis at this point?
I mean, I guess if we tend to consider distribution to be more serious than possession, the only possessions that we had were those that were, and I'll go back to where that was, were the ones that had the marijuana transport into the Commonwealth, 5 pounds or more. So by our traditional hierarchy, where possession is not as serious as distribution, those would be the least serious on our scale.
Okay. Is Gracie Berger from the Last Prisoner Project on our call today? No. Okay. Are there? Well, I have a bill that had been drafted in case we decide to move forward with it. That basically it allows for someone who's convicted of a marijuana felony to have a hearing if it was exclusively a marijuana felony, like importing more than 1 ounce, or having multiple felonies on the same date, including marijuana, to have a rehearing. And then if someone had an enhanced penalty based on prior marijuana conviction or marijuana requisite to another charge, that they could petition the court for a hearing. Are there members of the committee who would like to address whether or not we should move forward with that and having the court have the option and the person be able to petition the court? Are there any comments on the committee?
Mr. Chair?
Yes.
Quick question. I guess for the witness, is she still on?
Yes, Dr. Selly?
Yes, I'm here.
Dr. Sully, I guess from what I heard, trying to synthesize everything that you said, folks whose most serious offense is marijuana related only, either possession or distribution. I want to make sure that number was 10, correct?
Yes, we only had 10 who their only offense, their most serious offense was marijuana.
Okay.
And those were all 10 of those were transported into the Commonwealth 5 pounds or more. And again, we're looking at the state responsible population, so
Right.
we wouldn't have the local responsible in the jails.
Right. Okay. All right. Thank you. Mr. Chair, related to that then,
Yes.
I heard your suggestion for a bill. I would assume that your bill would immediately release those 10 people now, and then those other folks can be eligible for that petition-based hierarchy that you've arranged.
The bill that was drafted that I have not introduced is to allow for an automatic rehearing of a marijuana felony sentencing. It wouldn't automatically release anyone.
Right. That's what I'm suggesting, that it be changed for those 10 people where the only offense is marijuana-related, period.
Right. Well, I would keep in mind that these are not for people who just possess less than an ounce. Some of them may have imported 5 pounds of marijuana into the Commonwealth, which is still a crime now.
Right, but
the sentence would perhaps change.
over an ounce is not in and of itself a prison. You don't get prison time for that right now. In our proposal.
Well, let me
I think
ask,
our proposal is up to, what is it, 5 pounds, Mr. May? If I remember correctly.
let me ask Dr. Selly, could you just drill down again? The ones who have a marijuana offense only, what the more serious offenses would be there? Or the,
Sure.
or the least serious offenses as well?
Okay, so we had 341 inmates with one or more conviction of marijuana, drug, or sales, but 331 of those had other drug sales. They were either meth, cocaine, or Schedule 1 or 2 drug. So that left only 10 that only had marijuana. And for the marijuana, all 10 of those were convicted of the marijuana transport into the Commonwealth 5 pounds or more. So we didn't, that was all that we had in our system.
And I understand that Ms. Berger is now on the line from Last Prisoner Project. Ms. Berger, if you're on the line, if you could unmute yourself.
I am, Senator. How are you doing this morning?
Good. Did you want to comment on the statistics that we heard or on a possible avenue moving forward?
Absolutely. Just on the latter, though, without reviewing this data, I won't comment on this specifically, but just to kind of give an overview of the legislative language that we've seen and been working with your office on. Kind of the purpose of the legislative proposal is to provide a legal mechanism to provide, as the member, I believe Scott, I'm sorry if this
yes,
is
Delegate Scott.
Right. Okay. Suggested immediate release for those individuals serving specifically just on marijuana convictions that didn't have other convictions attached. So that legal mechanism currently does not exist to provide relief for those individuals. So the legislative proposal would try to provide that, as well as a couple extra tiers for individuals that are serving sentences that were arrived upon because of cannabis prohibition and enforcement, but perhaps do have other convictions for, as the Department of Corrections representative said, for perhaps other drugs and perhaps other convictions. So those sentences would then receive a hearing for the bench to consider whether those individuals have served enough time for everything that they're sentenced for in light of legalization. So were they sentenced to more time than perhaps they would have been had legalization been in place when their sentences were handed down. So it's kind of a 3-tiered legislative proposal.
Thank you. Delegate Scott or others, any reaction or comment?
No, I will not be in favor of any bill that doesn't call for immediate release of those 10 folks.
Okay, so
that's all I need.
Okay, so I hear some sentiment for those 10 people to be released, even if it's still a crime to import more than 5 pounds of marijuana into the Commonwealth. I mean, I know it'll be different penalty. So, okay, I think you made yourself clear. Is there any other?
I just visited a medical provider last week, and there were thousands of pounds in there. So yeah, I think those 10 people deserve an opportunity to come home.
Okay. Is there other comments, discussion? David, I hate to put you on the spot, but do you know what the penalty under the bill that we passed last year for importing into the Commonwealth 5 pounds or more would be?
Mr. Chair, I think, I was just looking right now, unless we have I know that if you possess more than, let's see, I believe if you possess more than 1 pound, you're guilty of a felony, period, regardless of whether you're transporting it or not, which is a jail offense.
So that's why I would tend to lean towards being able to petition for the resentence rather than an automatic result. I don't know if there are other members who have comments at this point. Delegate Herring?
Yes. And I forgot her name. I'm sorry.
Ms. Berger from
Ms. Berger, yes.
Project.
I know we were talking about 5 pounds or more, but do we know how much was the most, what's the top sort of, how many pounds? Are we talking, right, 1,000 pounds of somebody who's convicted of 1,000 pounds?
And that might be for Dr. Selly from the Department of Corrections, if you could answer that. I don't know if you're aware.
I'm not aware. That would really take us a special investigation to see if we could find out what the cases or the facts are. We just know what they were convicted and sentenced for.
All right. Thank you.
Thank you.
Okay, thank you. Well, where we are on this is we have the concept of people who had been received either a marijuana felony or a multiple felony on the same date, including marijuana, or an enhanced penalty based on a prior marijuana conviction or marijuana requisite to another charge, whether or not they should be revisited by the courts and have to, whether that would be automatic or in the case of, as it would be for marijuana only under what I have before me, or being able to petition if it was an enhanced penalty based on a prior marijuana conviction. I don't know if there's any other thoughts from members of the committee. I'm gonna set this aside, and unless there's questions for either of the two speakers.
Mr. Chair,
Yes, Senator McPike.
I just wanted to follow up on the local responsible potential inmate number. If we can have that information to understand what the universe is and what the potential impacts. I know that Department of Corrections doesn't have direct data, but maybe there's a way we can get that.
Well, let me ask Dr. Selly. The locally responsible inmates ostensibly are serving a year or less, and since marijuana has been decriminalized for more than a year, is there any way to know what would be the easiest way to determine if there's anyone in locally responsible incarcerated for a marijuana charge?
If it were me, I would ask the compensation board. They tend to know have the most information on the local responsible. But indeed, if it's a year, they would be a year or less. So assumably, they would be clearing out pretty quickly after the bill passed.
Okay.
Mr. Chair.
Yes, Delegate Scott.
I can attest, and I don't know if Dr. Sully has some new information, but I just visited some guys on Friday that are doing way more than a year, and they're in local jails and have been for over a year because of COVID. So I don't think that that answer is accurate right now. Thank you.
Okay. Well, I'm happy to get in touch with the compensation board and see what we can determine. If you or other members of the committee are interested in this bill further, we can talk about it offline as well. But Delegate Adams.
Thank you, Mr. Chair. I have a question for Dr. Sully, please. I want to clarify, are there any people currently serving time who strictly have marijuana offenses that are up to a pound that have been serving since we decriminalized that section of the code?
Right. When we looked at the data that was as of August last year, the only ones that we found that were only marijuana, had a marijuana most serious offense, which would have been really at the lowest level for our lines of most serious offenses. There were only these 10, and some of them maybe, I haven't updated to look at when their releases, some of them may have already gotten out or maybe getting out soon, but these were the only 10 that we had as of August.
So follow up for clarity, but I'm asking specifically because there was much talk about 5 pounds. I'm asking a pound or under. Is there anybody currently incarcerated with that amount?
There may be people that are incarcerated with that amount, but they have a more serious offense.
Thank you.
Also.
Okay, thank you. If there's nothing else on this topic, I'm going to move on to our other discussion items and start seeing if we can come up with some recommendations. First, we've got the cultivation categories that Delegate Adams had explained, the idea of having a single cultivation license class for consumable cannabis products. Was there any objection to that or questions about it? Okay. Then I'm going to call for a vote as a group, but if people have questions or objections to individual pieces, let me know as we go, and then we'll do a vote at the end. For hemp inclusion, we heard discussion about a rigorous RFP process for up to 5 vertically integrated industrial hemp manufacturers being allowed to engage in a license with a limited class of participants to meet the same standards as pharmaceutical processors. I know Delegate Herring had a objection to that or uncertainty.
I'm sorry, I just want to be clear on one. It's not an objection. I just think that it's important that we take care of that as well as the other aspects of social equity licensing.
Okay.
So that
was there other social equity discussion that
didn't occur.
assuage your concerns yet, as of yet? Okay. Then we've got the open container issue, and I'm going to ask the council, had you arrived at any language on tightening the open container language to remove ambiguity?
Mr. Chair, we have not. We're working on that today.
Okay. Then we came up to social equity with the suggestion from Senator McClellan to, instead of just saying someone who was significantly impacted by cannabis arrest, significantly impacted as a dependent of a family member of someone arrested or they had been arrested themselves. JLARC had recommended access to expunged records for the Cannabis Control Authority, giving them the access to sealed and expunged records for the express purpose of reviewing equity applicants. Then in terms of personal manufacture and extraction, JLARC pointed out that there's no explicit penalty levied for the violation, but that we prohibit personal manufacture and extraction. In other words, if someone was going to make a food product out of cannabis, that's currently not allowed. And I was interpreting JLARC's note to suggest that perhaps we should allow for safe legal personal manufacture and extraction of cannabis products. Normal had pointed out that on the Public Health Advisory Board that there's no consumer safety and cannabis toxicology members on that board, and we heard testimony at our last meeting from someone who obviously would be well qualified to serve in that regard. I was going to suggest that. And then as it came to lab testing, we also had heard discussion and was going to suggest that we enact changes that would allow DCLS to be vested with authority over testing standards and truth in labeling testing for independent lab testing of cannabis products. And last, on my list of things that we had not decided was public health and information campaigns. I was going to suggest, since we're talking about an expedited timeline, that we endorse putting more money into increased funding for public health campaigns, and I can put in a budget amendment. Someone may want to do that in the House. I was going to suggest that we do up to $1 million, which was the amount allocated for the first year that has not yet been spent. But I think now that the Public Health Board is up, that they will be able to spend it more expeditiously. So I'm going to ask that on those new items that we go through and actually take a vote, and I'm going to isolate, I'm just going to call them out one more time.
Mr. Chair,
Yes, Senator McClellan.
before we do that, other than having a similar document distributed at the last meeting, I'm not sure the public has had a chance to weigh in
Okay,
on what we've done, so we may want to ask if anyone
Okay.
in the audience would like to
Let's
speak.
do that. Let's take public comment now for up to 2 minutes per speaker on any of the topics mentioned or anything else that you think that has been left out of today's discussion. Just approach the microphone and introduce yourself.
Howard Flinner. I'm from Chesapeake, Virginia. Glad to be here. I do have a few things I would like to mention that I haven't heard mentioned. Would like to address the topic that came up last month's meeting. Mr. Jamerson from Juchi was representing Juchi of up in Richmond or up in Northern Virginia. He failed to mention that Juchi is part of Juchi Holdings, which is a 5-state, 28 dispensary company right now. They're looking to become the world's largest cannabis provider. Okay. I want to go through this. He had mentioned that fentanyl was being put into cannabis. And, I'd like to know where he got this information. It's absurd and not unlike pharmaceutical representatives to lie right to your face if it furthers their cause. Pleading the fifth, perjury, and contempt is all that Americans have seen if they watch the U.S. Senate question these CEOs and representatives. We have watched what the pharmaceutical companies can do, such as inflate prices on their products, not only contributing to the opioid epidemic, lied to the FDA, lied to the American people. People die every day and continue to die from drugs that the pharmaceutical companies manufacture. And they are aware of this. With scientific certainty, they know that deaths or serious diseases are occurring from the use of these cocktails. Allowing it to continue for the sake of profit is getting very old to the American people. And our government approaches how our government approaches the pharmaceutical industry in the future should be monitored by the FDA with a hell of a lot of transparency so that so they can gain the trust of the American people again. Death or disease has no place in medication that is supposed to be treating or curing you for something entirely different.
I'm going to ask you to wrap up your remarks.
I have a couple things I'd like to mention, if it's okay.
If you could be brief, because you've gone over, I think, the 3 minutes that were allocated. You can continue, but if you could, just summarize.
All right. I'd like to mention a book that's written by a gentleman, Jack Hare, The Emperor Wears No Clothes. It is a well-known cannabis activist. He has since passed away. I implore you to send a copy or to read a copy. It's a fascinating book. I'll leave that. Cannabis bar. Senator Abbott mentioned cannabis bar last meeting, which would be better termed a cafe. Most other states that have been enacting new cannabis policy have also licensed establishments where responsible adults may use cannabis, much like Virginia's ABC oversees the establishments that serve alcohol. There are stipulations such as no alcohol sales or consumption of any kind, no tobacco sales or consumption of any time, and no one under 21 at any time. The Cannabis Oversight Commission can and should adopt the stipulations as well as enact any others that they find necessary. This would also, for so many more opportunities for individuals to profit from the new cannabis industry, as well as provide many other employment opportunities. Delta 8, Delta 9 pharmaceuticals and laboratories. Pharmaceuticals and labs if they have anything to do with it, they will isolate compounds, cannabinoids, like the Delta 8, just like they have done. It's right here, Delta 8. Letting the pharmas and labs control and manipulate cannabinoids so they can create other cocktails to serve the public should not be an option for this commission.
Thank you, Mr. Flemmer. Thank you for being here today.
Thank you.
Okay, were there others who wanted to speak to us before we take any votes? 2 minutes.
Mr. Chair and members of the commission, my name is Reverend Lester D. Fry, and I am the pastor of the Healing and Living Waters Ministry here in Richmond, Virginia. I'm also the first vice president of the Baptist Ministers Conference of Richmond and vicinity, and I'm also the program director for the BMC, the Black Coalition of Change. And I'm here to share with you and speak to you from my position as the first Vice President of the Baptist Ministers Conference, along with many other clergy organizations, clergy and church leaders, thousands of congregation members, community leaders, and grassroots advocates across the Commonwealth of Virginia. From the onset, I want to share with you that there are widespread concerns about the legislation of cannabis in Virginia. In fact, many are downright fearful about exactly what is going on. Their fears are legitimately fed by the realization this legislation came out of the clear blue sky and caught many completely off guard, as it was debated at a time in 2021 during the height of the COVID pandemic, when everyone was kind of hunkered down. Very few in our community are clamoring loudly to legalize cannabis to the extent this thing has been put on the fastest track that it could possibly be on. Based on feedback from leaders in many of our communities, there have been countless conversations and sessions listening to questions and concerns about what is happening to our family and our children and our community and institution, including churches across Virginia. Both voters and residents in communities across Virginia are very confused about the lack of information, details, and well-attended public community meetings put on by the state officials aimed to explain exactly what is going on, to answer questions and learn the effective legislation of cannabis will have on our most impacted communities.
Reverend,
There are so many questions.
To summarize and conclude.
Yes, sir. There are so many questions that the modest website can't answer them all. And what we're saying today is that we should look at the communities that are hardest hit by the drug traffic over the years, and we should make provisions for them to things to happen so money can be allocated so that we can get some of the tax revenues that are involved in cannabis so that we can help our community. I thank you for your time.
Thank you for being here. I will point out that that in last year's public hearings during the COVID pandemic that we took remote testimony and that hundreds of people, both pro and con, did testify. But
Mr. Chair, I just had to briefly address, because there were provisions in the bill for money to go to impacted communities, especially for early childhood education for children, and also with business licensing. So, and that's why I wanted to make sure that we talk about all the social equity provisions to make sure that those communities impacted, and especially children, are taken care of. So I appreciate your comments.
Thank you, Delegate Herring. Okay. Thank you.
Mr. Chairman, members of the Commission, Hunter Jamerson for Jushi. Appreciate the opportunity to speak to you this morning. I'll be brief. Jushi is very proud to be the licensed pharmaceutical processor in Health Service Area 2, servicing the Northern Virginia area, and very appreciative so many of you have made the trip to tour our facility, and welcome all of you to do so at your convenience. I did want to refer you to the July 8th Washington Post, which highlighted the sale of fentanyl-laced cannabis in the Commonwealth of Virginia. I believe this is a very important issue, which is driving the need for expediting the sale of regulated cannabis in the marketplace so that we can bring safe products to Virginians and not risk public safety as we move forward. Finally, just want to comment briefly as a participant in the meeting with Mr. Griffin and Purely Appalachia, as well as Golden Piedmont Laboratories, discussing a future lane for hemp processors. I think there were a few themes I wanted to make sure were brought to the Commission's attention. The first were that there's opportunities to expand the current ingredients that hemp processors are able to sell to the pharmaceutical processors, expanding beyond CBD oil into other extracts. We're very committed to partnering in that quest. Likewise, as the marketplace expands beyond the 37,000 medical patients to 800,000 adult use patients, hemp will be well served by the opportunity to sell those ingredients to service a much larger marketplace. And finally, there was discussion of an RFP process. I can speak only for Jushi, but we would also be committed to a process on those terms, subject to the standards of just as safe and just as regulated, which we think means an indoor cultivated product. But we look forward to working with the Commission and the hemp industry on this. And if there are going to be preferences established in terms of throughput and timeliness of licenses, we think also that's the opportunity to establish preferences for social equity in any future licenses as well. Thank you.
Mr. Chair.
Yes,
May I
Delegate
ask
Adams.
Mr. Jameson a question real quick? May I ask him a question?
Yeah, there's a question for you.
Mr. Jameson, are any of the medical providers already delivering, or are you not delivering yet?
Mr. Chairman, Delegate Scott, each processor operates differently, but the regulations do permit us to deliver today.
Okay, thank you.
Yes, sir.
Welcome.
Thank you, Mr. Chairman and the Commission. I'm Michelle Peace. I am a forensic toxicologist employed by Virginia Commonwealth University and the Department of Forensic Science. I have a research laboratory there. I'm also the CEO of Cardinal Quality Laboratories, which is a laboratory located here in Richmond to provide third-party quality assurance testing for the hemp and medical marijuana industries. And I do want to make comment with regards to using a state laboratory to establish standards for quality assurance testing. In the sphere of forensic science, I have sat on boards that have established standards for the forensic toxicology industry. From start to finish, it took us 8 years to establish a consensus for standard testing for forensic toxicology. So using a government laboratory to establish those standards, we are going to be a long time coming for a standard to be developed. In addition to that, I will make a plea that a government laboratory is not built for production and efficiency. And so the standards that could potentially come out of a government laboratory establishing those methods will be inefficient and expensive. And as a result, could really jeopardize the viability of a third-party testing lab that already has very small margins in which they are already operating. So you might want to ask then, well, how do we assure that the laboratories are doing good, solid, repeatable, trustworthy work? And that already lies in the provisions that you have made in your legislative language, which requires accreditation. A requirement for accreditation is proficiency testing. And proficiency testing is the bar for laboratories, for quality assurance labs, to ensure that they are doing good, repeatable, trustworthy work. And so I would just plea with you to stand with what you have in terms of requirements for accreditation and abandon the requirement that all of the labs in the Commonwealth use a single standard method. Thank you.
So just to be clear,
Yes.
the language that I had about allowing DCLS to be vested with authority over testing standards and truth and labeling testing for independent lab testing of cannabis products, that's acceptable?
No.
Okay, so how would you word it? Say it one more time, what your position is.
My position is that
Accreditation?
I'm sorry?
You mentioned accreditation.
Yes. The accreditation requirement, as it is, you've required accreditation for ISO 17025. A requirement of that language, for accreditation language, requires proficiency testing. That is a requirement of the accreditation. And so therefore, if laboratories have ISO 17025 accreditation, they will be required to undergo proficiency testing. So that's already accounted for.
Okay, and that was the way it was in last year's bill?
Yes, there is provision for accreditation to be a requirement.
Okay, and were you familiar with the JLARC report?
Only moderately.
Okay, just in terms of that topic?
Uh-huh.
They have had some issue with it, but you're fine with the way it was last year?
If I could, I would like to go back and review the JLARC report.
Okay, well, let's stay in touch, and I'd like to talk to you after the meeting's over.
Absolutely.
Okay.
Thank you.
Thanks.
Thank you.
Thank you. Hi, sir. Welcome.
Good morning. How you doing? My name is Dashawn Robinson. I'm here representing Old Manchester Hemp Company, which is a hemp company in Richmond, Virginia, over in Old Manchester on Hull Street. And today I just came up 3 quick topics I heard you speak on that was not addressed properly in my opinion. Social equity. The license application process that you're speaking on, being a minority, looking at social equity is too far-fetched. You're expecting a person who has been impacted by a marijuana charge, minority, family impacted, to have $1 million to apply for an application.
I hate to cut you off, but let me just, I should explain. The $1 million fee is for people who are not social equity applicants, for people who are already engaged in pharmaceutical or possibly hemp business, and it would be, and that money would be bankrolled possibly to help people get a foothold who wear equity licenses. But we were not talking about charging equity applicants that kind of fee.
But with the points of a person being impacted, minority, to be in a position to apply for an application to this magnitude is a little far-fetched, and I think you should revisit that and look a little more into detail of what person's impact would be. The average person I know, being from Richmond, Virginia, that would want to apply for this license on a social equity aspect would not qualify. Most persons are in poverty based off of what their mother or their aunt, whoever was raising them that was impacted. A lot of persons don't bounce back. Some persons do. They are rare people. But in my opinion, it's a little far-fetched. It's a little, it needs to come down some. And I just ask you to revisit that and look at it in totality. The second thing, we spoke on growers. I'm going to be real quick. If you issue 5 licenses to hemp growers, which we are hemp cultivators ourselves, these persons cannot produce enough product to supply these other facilities. I also heard the young gentleman speak on growers. Well, if you have received a license to cultivate, to supply these facilities, and you're reaching out to growers now to help you get your product, where their license. How am I going to grow and sell to you to sell to the dispensary if I don't have a license to cultivate cannabis, only CBD? So I just want you to revisit that as well, because it's bigger than just 5 or 10 small companies or bigger companies. The local persons here should have an opportunity. Like we fought for this. We've been impacted in this community, and the bigger companies coming from out of state, out of town, we should have a fair share as well. They have a big lead, a year or so, 2 years or so of growing and cultivating, and look at where they are compared to growers like myself who are still struggling. We're losing money trying to grow hemp, trying to produce hemp, but now we're being put in this category where we might have to wait another 3 or 5 years while other companies come here and get that much of a head start. And am I for certain, being a Virginia resident born, that you're going to put that money back into Virginia, to these school systems, to everything that has reached poverty, and these people are brought out of bad situations. And I just want to speak on those things.
Thank you for being here.
Mr. Chair, I do have a
Delegate Herring.
So can you give me a suggestion about how to make the social equity license not far-fetched? If you think it's far-fetched, like what improvement would you recommend?
I agree. I'm a historical black college graduate myself. So I understand for persons who went to historical black colleges. but I don't think that should be like the main standard. The application process should be different because, again, we don't have the same benefits as the bigger companies have, financial-wise, stability-wise, and we should have an opportunity. Some things just need to be revisited. Tax bracket, like I can't compete with Greenleaf, but
So you're talking about sort of access to capital.
yes,
That's what you're saying?
not just the capital, but the knowledge, the green light. Like these other companies giving the green light to come in and learn how to grow, test their products, produce oils, everything. And persons like ourselves, because we're waiting on this social equity aspect, because I cannot, be honest, afford $1 million on the application fee right now if I had given the opportunity. But on the social equity aspect, being a Virginia resident, it's some of those things that need to be revisited. Not just if you were impacted by a marijuana charge. If you look at cocaine or crack on the federal level, most of the young minorities like myself, they were sentenced based off the weight of marijuana. 5 grams of crack was equivalent to a ton of marijuana, and that was a mandatory minimum of 5 years. Makes no sense. So I just wanted to look at those things.
All right, thank you.
Thank you.
Thank you, sir. Were there any other comments from members of the public before we proceed with taking action and recommendations? Okay. So I think what I'm going to do is just go through what we had discussed at our last meeting first and take it up in a block. We had at the last meeting just kind of asked for objections. I don't think we took a roll call vote. So I'm going to list the items. The first is that the Cannabis Control Authority be vested as the single regulatory authority for cannabinoids, hemp, Delta-8, Delta-9, cannabis, and pharmaceutical. The second was that we would allow for the sale of seeds and clones by pharmaceutical or, I would say, hemp, any authorized retail points for cannabis at that point. Delta-8 would be included. We would include regulation of Delta-8, Delta-9, again, under the ZCA. License classes, we would allow the regulator to create different classes of license within each license type. In other words, size and so forth. Timeline for the commercial market, we at our last meeting discussed moving up the date for implementing regulations and accepting applications to January 1st, 2023, allowing 1 year for the market to be established. This is beyond the early sales. Special use zoning, we would prohibit localities from applying special use zoning to cannabis business unless it is used on other similarly situated businesses. In other words, they can regulate agriculture like agriculture, or retail like retail, but not single out cannabis. Referendums, at the request of VACO VML, we discussed clarifying that towns are not subject to a surrounding county's opt-out referendum. They can have their own referendums. Hours of retail operations, at my suggestion, we suggested that we would allow for hours of retail sale to be no greater than the hours for ABC stores in Virginia. Public consumption, it's currently an elevating penalty, which is hard to track on the spot if someone's already been charged, and we discussed keeping it at the same fine of $25 per offense as was state law pre-2021. We discussed for earlier sales, allowing for earlier sales to begin on January 1st, 2023, under the Cannabis Control Authority, particularly for pharmaceutical, and we'll get to the hemp people as well, the next block. And license caps, to allow the Cannabis Control Authority to set license caps for cultivation, processing, wholesaling, everything except for retail. Retail licenses are in last year's bill, the cap. So those are the actions that we discussed at our prior meeting. I'm going to ask for a motion to approve those actions.
Sorry, Mr. Chair, I apologize.
Delegate Herring.
I just want to make clear, are discussions with hemp and medical processors ongoing still, or is there a representation here that there has been a deal?
Well, this would allow it for the medical, and the next block would allow it for hemp as well.
Mr. Chair.
Yeah, Senator McClellan.
So that we're all on the same page, the recommendations that you just read are the ones that we voted on by a voice vote at the last meeting.
Right.
And you were just asking.
We didn't take a roll call.
Right, so it's not the entire list, we're taking them in chunks. First voting on the ones that were voted on last meeting, then we will address them.
That's correct. There's
Okay, thank
two blocks. The first block are the ones from the previous meeting. And I was going to ask the clerk to call the roll unless there's other questions about this particular block, the first block. Okay, could you call the roll?
Mr. Chairman,
Yeah, yes, Delegate Moorfield.
I would like to make a comment before we vote on this. So, first of all, thank you, Mr. Chairman, and the members of the commission for all of the work that you've done on this commission. I think whether or not you support marijuana or you don't support marijuana, the reality is we already have laws on the books, and I think it's only responsible that Virginia fall under a very well-regulated market. We've seen around the country what unregulated markets can do. And so with that being said, I think that because of the fact that we already have laws on the books, it's only responsible, whether we support marijuana or we don't support marijuana, that we fall under a very well-regulated market, because if we don't, we may end up with something that could be a complete disaster and completely devastating to so many people across the Commonwealth. Thank you.
Okay, I'll treat that as a motion for the first block. Is there a second? Second. Okay, it's been moved and seconded, so clerk, please call the roll on the first block.
Senator McClellan. Senator McDougal.
Aye. Sorry.
Senator McDougal. Senator McPike.
Aye.
Delegate Adams.
Aye.
Delegate Campbell. Delegate Krizak.
Aye.
Delegate Moorfield.
Aye.
Delegate Scott. Aye. Delegate Herring.
Aye.
Senator Eben.
Aye.
Senator McDougal. 10 ayes, 0 nays.
Thank you, Madam Clerk and members of the committee. Now, the second group was items that were discussed today. They include cultivation categories to have a single cultivation license class for consumable cannabis products to be set by the CCA, to include a rigorous RFP process for up to 5 industrial hemp purveyors to be vertically integrated, meeting the same standards as pharmaceutical processors, with a limited class of participants to those who had a license registered prior to March 31st, 2021, and those who have processed more than 40,000 pounds of hemp under their permit. I'm going to skip on your chart, the resentencing policy and open container for now. The social equity program eligibility, to amend last year's bill to say that we would give social equity applicants priority if they had been arrested or had been significantly impacted by cannabis arrest as a dependent of a family member of someone arrested, to be fine-tuned in regulation by the CCA, or if they were met two of the following: resided in an economically distressed area, resided in a high marijuana law enforcement area, or a graduate of a Virginia HBCU. That we would give the Cannabis Control Authority access to sealed and expunged records for the express purpose of reviewing equity applicants only. That we would allow for safe personal manufacture and extraction for home manufacture for personal use. That the Public Health Advisory Board be increased to include a member of the a consumer safety and cannabis toxicology member. Was that for two separate people? I'm sorry, to increase it for to include a consumer safety advocate and a cannabis toxicology member to the Public Health Board. Then to increase funding, and we can discuss further how we'll do that in the budget amendment, but the concept of increased funding for public health campaigns. So what that leaves out of the written list that members of the committee had, and we can come back to them in a moment: resentencing policy, open container, and lab testing. Is there a motion to approve those? Yes, Delegate Adams has a question.
would you be open to adding the word define when it said the part about being substantially impacted? Could you have the, you had said like they could tweak it, but could you put the word, sorry, so that there was a charge to actually like put some substantial, like criteria of what substantial means?
As a dependent of a family member of someone arrested.
No, it was higher.
Defined, okay. So you want to say something to the effect of that equity applicants would include those
Where
who...
it said significantly impacted, like define what significantly impact as a definition?
Well, I think what we were, and I'm going to ask Sarah McClellan to weigh in on this, but I think she suggested just by being the dependent of a family member who was arrested, that would significantly impact you. Was that your intention, Senator, or?
Let me back up.
Yeah.
My recommendation was currently the legislation is a little bit broad to just say that you are a family member and it lists different types of family members. My recommendation is to amend the legislation to limit that to family members who are dependent. To answer that specific question, but as the chart says, is we would vest the board with the authority to define what significantly impacted by a cannabis arrest means, and that we would not do that in the legislation itself.
I didn't see define.
Okay, Sarah McClellan, are you suggesting that being a dependent alone is enough, or that you would like the board to be able to weigh in further?
So I'm a little confused as to what the as I understand the current legislation, if you were one of the enumerated family members, that was enough. Is that correct?
Yes.
So part of this would be to say if you were one of the enumerated family members who was a dependent,
okay,
that would be enough. But then we have the or that says a person, well.
Oh, I see what you're saying. Yeah.
Mr. Chairman?
Yes.
When you're saying dependent, that's, I guess, legal term that somebody is financially or in loco parentis. So couldn't you, in essence, be a child, but another party have custody of you and you not be dependent upon that individual? So is that really what you're trying to accomplish?
I think I was going for dependent, the adjective, perhaps not the legal term, so.
No, Mr. Chair, okay, let's back up. The purpose for the recommended change was JLARC had identified that under the current legislation, you could have a huge number of social equity applicants.
That's correct.
Solely based on their status as a family member. Not all family, like some family members would have been significantly impacted and some would not. Just your status as that family member in and of itself is probably not enough. One category we know would be enough is if at the time you were a dependent. That should be automatic. If you were a dependent at the time, you should automatically be eligible for a social equity license. So that was what my recommendation was.
Mr. Chairman, I just want to be clear. If you were living with your mother, you're a minor, and they were incarcerated, you're a dependent. But if you were living with your mother and your father, who might have loved them and had big impact on you, and they were incarcerated, but you were not living with them and they were not financially responsible, then I don't think that you're going to be a dependent of that individual, at least for a number of things you wouldn't necessarily. So I don't know that that's the goal. That's why I was trying to understand.
Okay, let's try and get Delegate Herring.
Just a quick comment, and this is Senator McClellan's amendment, but for me, my vision is that those individuals who are children who are dependent on that parent financially, and like you said, in local parentis, where all of a sudden they get a conviction and their lives are, turned upside down. And that's what I think was initially envisioned by the poorly or a little bit broad language of the original bill. So that's just my 2 cents.
Let me read something, Sarah McClellan, get your reaction. The CCA shall define social equity applicants significantly impacted by cannabis arrest, including dependents of someone arrested. Is that not, that doesn't capture what your intent?
If you, at the time of the arrest and incarceration, were a dependent of that individual, my amendment would say you are automatically eligible for a social equity license.
Right.
If you are not a dependent, you could still be eligible under the other criteria. So that's what I'm saying, is that we want to ensure if you are a dependent, you qualify. If you are not a dependent but a family member, you could still qualify.
Okay. So what if we were to word it as follows? The CCA shall define social equity applicants significantly impacted by cannabis and arrests, which shall include dependents of someone arrested. So in other words, if you're it doesn't say incarcerated, it says arrested.
Okay. I mean, if you were arrested and acquitted.
If you're arrested and you can't get a job because you have it on your record and you lose your driver's license prior to a few years ago, and
If you were arrested but acquitted, what happens?
well, there's a deferred disposition right now where you can have your conviction vacated after 6 months of paying a fine, random drug testing, in some cases losing your driver's license.
Ms. Chair, and maybe Delegate Scott can help me out. Just because you are arrested, if you're arrested and you are acquitted, what you just read said that your dependents would be eligible, but you weren't impacted. You were not impacted. If you were arrested and convicted, or you were arrested with a deferred disposition, I think arrested is a little broad.
Okay, or what if we were to say,
Well, first I want to make sure Delegate Scott is agreeing with me, because he practices in this area and I don't.
These guys do too, so I'm going to defer to them. They do way more no, I do a lot of it, and I'm sure they do too. I think deferred dispositions and arrests probably a lot different impact than somebody who has a conviction, obviously. So I think any conviction for possession, misdemeanor, or felony, not just felony. Because I think even a misdemeanor conviction for marijuana, I know truck drivers right now who can't get security clearance to get on base because they have a misdemeanor conviction from 20 years ago. So I think we need to talk about what that looks like. I don't know if the arrest alone is enough. I don't know if a deferred disposition that will be dismissed at some point in the future is enough. But I think any conviction related to marijuana, either misdemeanor or felony, is enough, I would think.
Agreed.
And I'll defer to these fine distinguished attorneys.
Before we move on to those other attorneys, I want to ask, is it not true that a deferred disposition can involve, at least up to a few years ago, losing your driver's license for 6 months, random drug testing that can interfere with the course of employment, and a fine, and that's a deferred disposition that can be vacated eventually, right? Is that not how it works?
I hope not. Normally, if it's deferred, the disposition is deferred, there is not a finding of guilt. That's why it's deferred. So there are no punishments related to it. It may be some conditions placed on having the disposition deferred, but it's not restricted. It's probably things like community service and other checkbox bookmarks that the court may impose on a person to be able to come back and say, I complied with everything, and now I should get it dismissed. And that's been my experience. I don't know what the other two.
Because to me, a deferred disposition is a significant impact, can be a significant impact.
I won't fight you over it. I'm just saying it's not the same as a if you want to include those two, I'm okay with that. I just don't want it to be just that's fine. If you want deferred dispositions as well as misdemeanors and felonies, I just don't want it to be felonies only because I know these misdemeanors have huge impacts on folks. That even though we're trying to get them expunged and do some other stuff, they still are there.
If we said that, I'm going to come back to Sarah McClellan and ask for help with wordsmithing this. If we said the CCA shall define social equity applicants significantly impacted by cannabis arrest, which shall include dependents of someone convicted or had a deferred disposition, along with those other categories at the end, would that be amenable?
I think so. I guess my point is it should be conviction, adjudicated delinquent. I'm looking at the language of the bill that we passed.
Okay.
And it says someone who is a parent, child, sibling, or spouse of a person who has been convicted of or adjudicated delinquent for, and I think we add deferred disposition, but it did not say arrest, and I don't think it should say arrest.
Okay.
Is what
Okay, well, if you were convicted or had a deferred disposition, or I don't know about adjudicated delinquent, were you in fact arrested to come to those things?
But my point is, if you were arrested and then
No, I get that. You found innocent
none of
or
those other,
something.
yes.
Okay. Okay, so let me just ask counsel if he wants to weigh in at all. If we were to use language saying something like the CCA shall define social equity applicants significantly impacted by cannabis arrest, which shall include dependents of someone convicted or who received a deferred disposition or who was adjudicated delinquent. Does that make sense to you, or is there other things that we're missing?
Mr. Chair, yeah, so if you're going to add it there, you probably need to add it on the first part, too, for people who are actually convicted. I think you added to the whole thing if you're going to do it.
Okay.
But, yeah, basically, my understanding is what we're looking at, we're not talking about, we currently don't give social equity preference for an arrest, and we were not, the significantly impacted would just be, I mean, we could play with that language and change that. It's really, you've still got to have that conviction or deferred disposition either way.
Okay, or adjudication of, as delinquent.
Right.
Okay.
So I don't think that when this chart was made that the emphasis was on the arrest so much as it's really ultimately the adjudicated, the conviction. That's
okay, the disposition of the charge. Okay, so you'll be able to work with that.
Right. So you'd have your three options. You know, you've been convicted. Splitting the family members, you're a dependent who was significantly impacted, you would qualify, and you might possibly qualify if you're a family member who was significantly impacted, or you meet two of the last three, which was economically distressed area, high marijuana law enforcement area, or a graduate of HBCU.
Okay. Okay. I think we're clear on that now, I hope. Okay. So we're going to call for a vote then on that block of items. Is there a motion to approve those? Okay, second. Okay. So Lindley, if you could call the roll for those.
Mr. Chair, can we just run through?
Yeah, let me do that. Okay.
Basic,
sure.
What blocks we're hitting first?
Sure. So this was our second block. It included creating a single cultivation license class for consumable cannabis products. It included having a rigorous RFP process for up to 5 vertically integrated, for up to 5 industrial hemp manufacturers to be vertically integrated, meeting the same standards as pharmaceutical processors, including the fee, with a limited class of participants to those who were registered prior to March 31st, 2021, and who had processed 40,000 pounds of hemp under their permit. It included the equity and the equity applicants as we just defined. It included the CCA having authority to access sealed and expunged records for the express purpose of reviewing equity applicants. It included allowing for safe, legal, personal manufacture and extraction for home use, adding a consumer safety advocate and a cannabis toxicology member to the Public Health Advisory Board, and increased funding for public health campaigns to be defined by what the dollar amount would be. So that would be the second block. So I heard a motion. Yeah, yes, David.
Just for clarification on the hemp processors, is this about vertical integration when the full market opens, or are you referring to allowing them to participate in the transitional sales market?
In the transitional sales market, yes. Okay.
Senator McClellan. Senator McDougal. Senator McPike. Delegate Adams.
Aye. Sorry.
Delegate Campbell. Delegate Krizak.
Aye.
Delegate Moorfield.
Aye.
Delegate Scott. Delegate Herring.
Aye.
Senator Eben.
Aye.
10 ayes, 0 noes.
Thank you, members of the commission. So just to be clear, what we did not arrive at final discussion on today, at least, is resentencing policy. We had discussion. I have a copy of a draft bill that I'm happy to discuss with any members of the committee who would like to put it forward, or we could see if someone else is exploring that area. The open container language, to tighten that language, we didn't vote on that because we don't have the final language available yet, but I would imagine that it'll be something that people want to see tightened. The exact wording is not yet available, and we'll get that to you. And lastly, on lab testing, I'm just going to have some further discussions and try and make sure that that we do the right thing, what that may be in that area. Are there other areas of discussion members of the committee have today on this topic? Okay. I want to thank everyone for being here and for your patience through all the deliberations. And with that, with no further discussion, we're adjourned.